Thank you, President. I rise to speak on the Justice Legislation Amendment Trial by Judge Alone and Other Matters Bill 2022. As indicated in its title, this bill has a number of purposes. The most significant change posed by this bill is the extension of trials by judges alone without a jury. It proposes to allow indictable offences to be heard by judges alone for another 12 months, provided a pandemic order is in place. Judge-alone trials were first introduced in Victoria in July 2020. The bill amending the Criminal Procedure Act was introduced as a temporary change to avoid unnecessary backlog in the courts while Victoria adjusted to the pandemic and restrictions on people gathering. Yet here we are, debating the extension of changes that were only ever intended to be temporary. The right to a trial by a jury is one of the few things guaranteed by the Australian Constitution. This is a testament to the fundamental importance of having criminal charges decided by a jury of peers, rather than a singular member of the judiciary. The right to a trial by peers goes way back before the days of Magna Carta. Juries uphold the notion of democracy by allowing the conscience of everyday citizens to be heard on issues at trial in a way that judges cannot always do. They allow for decisions that are representative of the community, and they go some way towards eliminating the unrecognised bias of judges. The last few years have thrown challenges to many aspects of life, including our justice system, that we of course need to adapt to. I fully understand the intention of introducing judge-alone trials temporarily to allow hearings to continue in the safest possible way and to address the issue of court backlogs. However, given the history and significance of juries, I do not think that any decision to extend judge-alone trials should be taken lightly. My concerns are somewhat mitigated given this extension is tied to pandemic orders. Under this bill, judge-alone trials can only be ordered while a pandemic declaration is in place, and for me that is of significant importance. Given we are again extending something that was meant to be temporary, I do not want this to be the beginning of the end for juries. This extension should be seen as a temporary measure to deal with the ongoing impacts of this pandemic, and any permanent changes to jury trials should not be something I would support. Juries are a foundational part of our justice system. They exist for good reason and they should stay. I am also pleased that this bill has kept a number of protections, including that the accused must consent to the trial being heard by a judge alone and must have obtained legal evidence prior to giving that consent. Everyday Victorians have not had the privilege of studying law like many of us in this place. They are not well versed in the rule of law, the Constitution, or the benefits of a jury trial. This lack of knowledge could be used to their detriment if it were not for the requirement to obtain legal advice. I am glad that this has been again included in this bill. This bill also seeks to allow for special hearings to be heard by judges alone. The purpose of a special hearing is to determine whether an accused person is guilty or not guilty because of mental impairment. Typically, the jury would hear evidence about the offending, review any medical evidence and come to a conclusion about the person's mental state and guilt. These special hearings involve vulnerable individuals and there is obvious benefit in these trials continuing. For the same reasons that I do not oppose the extension of judge-alone trials, I do not oppose the extension for special hearings relating to mental impairment. Another part of this bill that I wish to touch on is the delay of the de novo appeal reforms. The Andrews Labor government boasted back in 2019 about how these reforms would make Victoria's appeal system more efficient and transparent while better supporting victims. As it stands, when a person is found guilty by the magistrates or children's court and appeals that decision, the county court must hear all evidence again and reach a new decision. It is said to place a considerable burden on victims and witnesses who are required to go and give evidence a second time, and also consumes a large amount of the county court's time. Under these reforms, the county court would hear the appeal based on the material that was led in the initial court. The idea was that this would speed things up and create higher quality cases in the magistrates' court and protect victims from reliving their trauma. We were told these reforms were about delivering more effective justice, so it is baffling that the government have now decided to put off the introduction until mid-2025, particularly in a time when courts need all the help they can get when it comes to efficiency. We have been advised in a bill briefing that the government need more time to ensure that courts have the adequate resources to implement the change. It is astounding that 3 years is not long enough for the Andrews government to implement their own changes. And finally, I wish to mention the amendments to the Occupational Health and Safety Act. Under the Occupational Health and Safety Act, any breach of a pandemic order or public health direction is taken to be an immediate risk to health and safety. Once something is classified as an immediate risk to health and safety, WorkSafe inspectors have the power to issue prohibition notices and shut down workplaces under Section 112. This means essentially that if a worker were to be wearing their mask below the nose, as they so often do, their employer could be hit with prohibition notices. The bill before the House today seeks to extend this power by 6 months. It was originally due to end on 26 April. I do not support legislation that provides major penalties for minor breaches. Other areas of the law have penalties that depend on the type of offence. They are not lumped into a one-size-fits-all category where minor breaches attract the same penalties as major breaches, nor should they be. A blanket approach leads to disproportionate penalties for minor breaches. Overall, this bill feels a bit like a band-aid approach. Extending judge-alone trials will not fix the deep-rooted issues of criminal backlogs in our justice system. It may assist, but it will not fix. Delaying reforms to de novo appeals means changes and efficiency is even further away. If we are going to recover and rebuild, the government need to be doing more to address these issues for good.